We are going to start. Thank you for coming. This is a panel, as you know, about harmonizing informal or customary and formal law. And I just lost my notes. But the fact that we're starting 20 minutes late, if you look at it in terms of the frame that we are, the topic is maybe an example. The formal law and program, rules and program would say that we should have started 20 minutes ago, and yet through practice and custom, things have gotten put back a bit. And so here we already have an example of that. My name is Tim Hanstad. I'm the co-founder of Landesa. I'm a lawyer. I've served on the faculty of law. Landesa is a nonprofit organization that works around the world, partnering with governments to help them change laws and institutions that provide secure legal rights to rural women, men, and communities. And a major theme of that work actually has to do with harmonizing informal and formal law, something I'll talk about in a second. We have a very distinguished panel today. And I'm going to spend some time introducing them and then some very short scene setting. And then start asking them questions. And the initial questions, they'll each have up to 5 minutes to answer. And then we'll probably have a round of follow-up questions. I've encouraged the panelists themselves to ask each other questions. And we'll spend about the last 30 or 40 minutes taking questions from the audience. That sound okay? Work for everyone? Okay, let me start with introductions. I'm hoping the information that I was given about each of our distinguished panelists is correct. If it's not, and I say something incorrect, please correct me. So, going to the very end, we have Hilary Tompkins. Hilary is a partner at Hogan Lovells. Lovells. She's a leading expert in Native American law in the United States. Hilary served in the Obama administration for 7+ years as a general counsel for the U.S. Department of the Interior, and that is the agency responsible for management and conservation of public lands, natural and wildlife resource programs, and the trustee for Native American tribes. Hilary is also a proud member of the Navajo Nation and is the first Native American to serve in that capacity as general counsel. So next to Hilary, we have the Honorary Hassan Jallow. He is the Chief Justice of the Supreme Court of the Gambia. He previously served as a prosecutor of the UN International Criminal Tribunal for Rwanda. He was appointed by the UN Security Council in 2012 as the first prosecutor of the International Residual Mechanism for Criminal Tribunals. And he's also served as Gambia's Attorney General and Minister of Justice.
Thank you.
Next, in order that they're seated, we have Dr. Ali Wardak. Dr. Wardak is a reader in Criminology, School of Humanities and Social Sciences at the University of South Wales in the UK. Originally from Afghanistan, his main teaching and research interests focus on comparative and transnational crime and justice, rule of law, and the relationships between state and non-state justice systems. He previously worked for UNDP in Kabul and is a leading world expert on the causes of conflict and what works in peace building. And last but certainly not least, we have the Honorary Eduardo Rodríguez Veltzé. He's currently Ambassador of Bolivia to the Netherlands, former Chief Justice of the Supreme Court of Bolivia, and former President of Bolivia. So he has a very distinguished and interesting past. I encourage you to look at the bios of each of them and look them up on Wikipedia, and you will learn many fascinating things that we don't have time to cover about each of their past. But so let me start with some scene setting. As I mentioned, I work in the area of land property law and comparative land property law. And one of the themes of that work around the world is the extent to which informal and formal rules and institutions are not meshed. In fact, almost all of the problems that we address working with whatever country it is that we're working with are rooted in that theme. Because in land tenure systems, everywhere, even in the most primitive societies going way back in human history, informal, customary rules and authorities evolve. And they evolve to meet the needs of the people and the communities living in those areas. And then, of course, as nation states develop, formal rules and institutions are created over time that gradually become dominant or play a larger role over those customary systems. But it is that process of formal law and institutions, usually gradually taking over for the informal law and institutions, is where problems arise. And so this meshing of informal and informal law is a dominant feature of the work that Landesa has done around the world. We often talk about if law is going to be effective in the area of land tenure, it should be both socially legitimate and legally legitimate. And so it's that meshing of social legitimacy with legal legitimacy that underlies much of, I think, what we're going to talk about today and what I'm hoping to pull out of the rich experience of our panelists. Because the informal or customary law, the informal institutions, often have the advantage of social legitimacy. They have disadvantages as well, and sometimes those disadvantages are highlighted more over time. So informal systems have advantages and disadvantages. Formal systems have advantages and disadvantages. And I'm hoping we can talk about what are those advantages and disadvantages in the countries and continents that are represented here. By the way, in terms of continents, I think we have North America, South America, Africa, and Asia. So pretty good coverage represented here on the panel. So with that, I will start with questions, and I'm going to start with Hilary. Hilary, your experience, particularly in the Obama administration and as General Counsel of the Department of Interior, had you working at the forefront, at least in the United States, of what some of these policy and legal issues at the intersection of formal and informal law. And I know you have lots to tell us about that. So could you just
Yes, happily.
share with us?
And I have a few photos I want to share with you as well. So let's see here. So first and foremost, serving in the Obama administration was a huge privilege. And one of the key things I learned in that experience was how a very complex federal legal system could be used to harmonize with tribal values and legal systems. And I think we were able to make that connection in a way that we hadn't really seen in American history. And so when I started as Solicitor for Interior in 2009, we had a mess on our hands. The Indian nations of America were very, very distrustful and had been very critical of the United States role as trustee. And so when we started this journey, we had over 100 Indian nations suing the Department of the Interior, saying, you are a very bad trustee, you did not manage our resources well, you did not manage the money related to those resources well, and we're suing you for breach of trust. There was also the largest class action history case in American history class action litigation involving over 500,000 Native Americans as well, suing the United States. Some people told me when I said I might take this opportunity on, you're crazy. Do not go and work for Department of the Interior. You'll never work in Indian country again. So real distrust and disconnect between those two systems. What did President Obama do? He said, I want to make this right. We need to start building that trust again between us in our trust relationship. So we proceeded to settle we settled over 90 of those cases, and we settled the class action case. And cumulatively, it was over $6 billion that we settled those cases for, going back to the Indian nations. That, to me, is a key to formal legal systems leadership, saying we're going to own this problem, we're going to admit we made some historical wrongs, and we need to do it differently. That reset the relationship with the tribes. Without that acknowledgement, without that legitimacy, saying we're going to own this, the United States will own these shortcomings and errors, that allowed us to move forward. And I think that's critical when dealing with formal, in this case, federal legal systems with tribal nations. So that set the stage. So 2 examples of what we did. The first is, and I think this picture is very emblematic of what we're talking about today. We have the Blackfeet Nation and their leadership. We have Secretary Sally Jewell, who was Secretary of Interior for the second part of the Obama's tenure, and then the head of a energy, oil and gas company. And they are signing lease cancellations of oil and gas leases in Montana near Glacier Park in the Lewis and Clark National Forest. These leases were issued in the 80s. They had never been developed. They'd been tied up in litigation for environmental challenges and historic cultural preservation challenges. And we came in and looked at the legal federal regime and applied that to protect Blackfeet Nation traditional customary use of the area, sacred use of the area. And Congress actually had, in the 2000s, removed all of that land from oil and gas leasing because of the sacred nature of that area. So the old leases were the only ones that remained. And this energy company, post our new election of a new president, so this was in December, I think, agreed to relinquish those leases and give them up because it was a recognition of tribal customary use, tradition, identity tied to this land. And then the second example, and one thing about being Solicitor of Interior, every day I walked in and there was an amazing new legal issue you'd never encountered before coming across your desk. This was in our last year of service. A Paris auction house was putting up for bid this Pueblo of Acoma shield. Pueblo of Acoma is a tribal nation in New Mexico, where I'm from. And the Pueblo had notified the auction house in Paris and said, do not put this up for sale. We do not believe in private property ownership of cultural items. This is abhorrent to our values. This shield was stolen from us in the 1970s. And at first, the auction house said, well, you can bid on this if you want it, which was completely offensive to the nation. So luckily, the Pueblo notified the Obama administration and said, we need your help on this. So the State Department and the Interior Department, where I worked, got involved. And we petitioned this auction house, said that it violated international treaties, it violated American law to allow for this item to be sold. And given that exchange, we were able to get them to not auction it off. It still has not been returned. And there is right now an in rem arrest warrant in New Mexico federal court, sitting there seeking the return of this item to the Pueblo of Acoma. Just an interesting note, in the affidavit of the Pueblo tribal member whose father was the holder of this shield, the daughter said, you know, that is the shield. Those feathers I don't recognize. And they believe those feathers were added to create some more, you know, flavor and intrigue of it being a native item for sale. So again, this is a federal legal system and federal agencies and leadership recognizing that there's no ownership of, individual ownership of the shield, that this is a shield that's used in cultural ceremonies, that those cultural ceremonies are part of the self-determination and governance of that nation. And so we were unified in those two value systems to stop the sale. So those are the two examples I have of how we tried to harmonize those values during my tenure.
Thank you, and I know you have many more examples. We're gonna come back to you later. But if I could move to Justice Jallow. I understand from our brief conversations that within your country you have a high amount of legal pluralism. Even you have customary courts, you have religious courts, you have then the formal courts. Could you talk a bit about the experience from your country in harmonizing customary and informal law? How does it? What works? What hasn't worked?
Thank you. Yes, I come from the Gambia, and as you've indicated, we have a pluralistic legal system, which is partly based on the English common law. So you have the normal magistrates court, the High Court, Court of Appeal, etc. And you have the Islamic courts, which apply personal law relating to marriage and inheritance. And then you have our customary courts, which also then apply the customary law relating to land, family matters, etc. And also they apply some local legislation, environmental legislation, public sanitation legislation, and also public order issues. They administer those. The country is divided into 34 districts, 35, and each of those has a customary court. They comprise elders in the community who are all lay people, and the court is presided over by the traditional ruler of that particular district. Lawyers don't appear before that court. They don't have any strict rules of procedure and evidence. They are noted for being speedy, and I believe having a just outcome to the case, even if sometimes as lawyers we have doubts about some of the processes and procedures, but I think the outcome is usually fair and acceptable to the community. They deal with the vast majority of cases in the country, especially land matters, because most of the land in the country is held under customary tenure. There's been some integration of those courts into the major system in the sense that the Islamic and the customary courts are all formally established by law, but their processes are pretty informal. That's why we bring them under the informal system. In terms of processes and procedures, they're very informal. In terms of establishment, they are formal, that they are backed by a law passed by the parliament, etc. There are separate courts for the Islamic and the customary courts at first instance level. That is the first time you go to court. But from after first instance, there is an integration at the level of the High Court in terms of appeals. Because all the appeals then go to the High Court, which are manned by judges and where lawyers appear to deal with the appeals, etc. So there is that integration at that level. But there is no harmonization in terms of the law. I mean, the laws, the customary law, the Islamic law, and the English received law still are separate compartments. And so it's up to the parties to have decided, to have chosen what system of law would apply to the particular transaction that is in hand, and then for the court also to decide, given the facts, what particular what particular law would apply. Sometimes you have conflicts. I mean, we have, for instance, at the Supreme Court, 2 cases that are pending for decision at the moment. One relating to wills and the other relating to marriage. In the wills case, for instance, you have a Muslim who has made a will which contradicts the Islamic law in the sense that he purported to give away more than 1/3 of his property, which Islamic law doesn't allow. It limits him to disposing of by will 1/3 of his property. The English law, of course, gives a relatively free right to disposal of your property as you wish. So we have this case of the person who has made the will. He's a Muslim up to the time of his death, but it does not comply with the Islamic law. And so the question before the court is whether, therefore, the will is invalid because it contravenes his personal law, or whether he has deliberately made a choice to opt out of that personal law into the English received law. So that question has to be settled by the Supreme Court. The other case relates to marriage, where a Muslim contracted a monogamous marriage under the Civil Marriage Act. Monogamous, it doesn't allow any other marriage. But the Islamic law is also recognized by the Constitution, and he has a right to it as his personal law. After he contracted the monogamous marriage under the Civil Marriage Act, he contracted an Islamic marriage as a Muslim, a second marriage as a Muslim with somebody else. And so he has passed away, he has died, and the question now has arisen as to the validity of the second marriage. So you have these issues which come up within the legal system as to which system would apply. I think by November we would have given our decision on these 2 cases. So there is some integration, but there are choice of law issues which are always there, which have to be decided initially by the parties, but ultimately where it's not resolved by the court itself.
Thank you. If I could move to Ambassador Rodríguez. You speak a little bit about the role of customary and informal, both laws and authorities in Bolivia. To what extent have they been formalized? What has been the process, and what has worked and what hasn't?
Thank you, Tim. We should go back probably like 400 years, because Bolivia, like other Latin American countries, were under just about 300 years of Spanish colonial cultures. That involves a legal culture that brought us a system, a monist system, a very positivist system by which the only law is the one provided by the state itself. Yet Bolivia, like a few other Latin American countries, have large indigenous peoples. And these peoples preserve their way of handling justice. Furthermore, we were under a legal pluralism, even in colonial times. Back in the 1500s, the King Charles V decided that the indigenous criminal justice system would be legal, or would be wise enough, as long as it does not contradict the Bible or the Catholic religion. So we've been sort of living in a classic legal pluralism system. But the indigenous communities were kept like a secondary way of doing their own justice. Yet that evolved over time in terms that these peoples became formal citizens. We had a number of political situations that brought them into full citizenship. And that's been going on for a while. I would say that in Latin America and in Bolivia, democracy has started to change things. And one of the most important things that democracy is changing is justice. Justice that it not only comprises the formal system, but the plural indigenous systems. And the question is how we go about having both systems working together. Interestingly, we had a new constitution drafted and passed back in 2009, in which we decided that Bolivia has become a country that is based on a plural society, based on legal, economic, and political pluralism. So legal pluralism translated into recognizing the traditional way of doing justice, but nowadays, since 2009, these indigenous justice systems, now they're constitutionally accepted. Mm-hmm. So how we reconcile both ways? And that's a major challenge. It's not easy because in one hand, we've decided, the country's decided through the Constitution that the way that indigenous communities handle their justice is formal, deserves full faith and credit. And on the other hand, we have the traditional way of doing things. At some point, we had a major debate over if it should be the Constitutional Court that would be deciding conflicts of competences, or kind of the same of issues that Judge was mentioning. But that has still a debate going on, because if we agree that the indigenous communities have their own way of doing things, why would a positivist way of handling justice should be deciding what they already have been granted? I'll just make a couple of examples of the debate over this harmonization endeavor. One is criminal justice. The traditional way of doing criminal justice provides that the state decides what's an offense, what's a crime, and it provides for punishment. Whereas in most indigenous communities, they have a different way of handling criminal justice. It's mostly a restorative way of justice. They don't have jails. Mm-hmm. They provide that whoever commits an offense has to repair the victim. It's mostly victim-oriented. So it is a different way of handling their issues in their communities. And so we need to decide if we were going to respect that way of handling criminal justice, or we're going to bring jails into their communities and prosecutors and hearings. Mm-hmm. So it's an ongoing debate. And I would just add something that it's an anecdote from yesterday. Actually, yesterday the International Criminal Court here in town celebrated its 15th anniversary. It actually was a happening that they carry out every year to celebrate international criminal justice. And I thought it was a good example of how politics and legal culture has to do in the way mankind feels about criminal justice. We had a panel, people who spoke about how important is criminal justice for international, in the international arena, for prosecuting genocide and all these kind of hard crimes. And for the understanding of the European panelists or ambassadors, it is a matter of sort of a balancing of the traditional common law system and the continental civil law system. And we were surprised that that's their way of looking at things. Whereas people from the South think, no, wait a minute, it's not just the common law and the civil law system. It's more than that. It's probably a more pluralistic way of looking at criminal justice. And we were just informally discussing that some of the cases that were heard and decided at the Hague were cases that come from Africa, where they had indigenous criminal justice systems that have nothing to do with common law or civil law systems. Mm-hmm. So just to wrap up, I would say that one of the challenges to harmonize things is it's cultural, the way we look at ourselves, and how we decide how pluralistic we decided to be. That has to do also with a debate over how we decide to be very positivistic, writing things, or allowing people to handle by themselves.
Mm. Fascinating. And Maybe speaking of criminal justice and its different systems, I know, Ali, you've had a lot of experience in your own country, but also looking comparatively at systems of criminal justice, of conflict, of peace building. And how do you think about this intersection of informal and formal law?
Yeah, but I think I need to put that in the Afghan context. And first of all, I feel very honored to be part of this distinguished panel and distinguished participants. Afghanistan justice system is, Afghanistan formal justice system is mainly based on civil law, French legal tradition, and Islamic law, very much modeled on the Egyptian and Middle Eastern legal systems. This justice system was thoroughly destroyed after the Soviets invaded Afghanistan until the collapse of the Taliban regime in 2001. And then the international community came to rebuild it. So I don't want to go into details, but until 2015, the United States alone spent over $1 billion on rebuilding the justice system. And yet, the justice system is thoroughly corrupt. It involves long delays. It is elitist. It is bureaucratic. Then we traditionally have had, like in Bolivia and Gambia, traditional justice institutions. They're mainly referred to as jirga and shura, but also increasingly religious institutions, NGOs, and other forums that operate completely outside the state justice system. There is no links between the two. Although about 80%, or some people say 70%, of disputes and offenses are dealt with by the non-state justice mechanisms, and yet there are no links. So the key question is, and what my research revealed in the past 15 years, one of the main reasons that people go to the traditional justice system, it is quick, it is speedy. It could resolve a dispute in a matter of days and a week. It is cost effective, it is free. You don't have to pay fees, fill forms, let alone bribes. And it is restorative. That is a subject which is close to my heart. You know, the retributive justice, I know there are many justice officials are present here. To me, the retributive justice that we have been following over 300-400 years in the Western developed world and everywhere else, it is not a success story. It is not a success story even in the Western world. Look at the prison in the United States. I live in the UK, and we spend about, on average, about £4,000 on keeping each prisoner per month, and yet 60% reoffend. So it is retributive justice, and retribution, in my view, overall is a failure. And restoration, traditional justice is restorative. Restorative, crime destroy relationships between victim offenders and the community. And if you further disintegrate the offender, send him to jail, obviously the research showed that you make them even worse, repeated offender. But restorative justice reintegrate offenders. It mends relationships between victim, offender, and the community. And restorative justice, informal justice system does not create losers and winners. Everybody is winners through mediation and reconciliation. And the reason I think quite a few of us spoke about ownership and legitimacy. People owns it. People are there. People are present. People see the processes. It is not elitist. And there is a Scandinavian, Norwegian academic who passed away, Nils Christie. He says, in the retributive justice system, the state, judicial professionals, they steal the case from the key stakeholders, which are the victim and the offender. The state become, and the victim is completely forgotten, whereas the victim should have a central role because he is the one who is affected. I don't want to speak too much about this. Now to come to the harmonization. In 2006, the United Nations Development Program in Afghanistan It employed me to write Afghanistan Human Development Report, which focused on rule of law. And in my research, I found that the two systems existed very profoundly. And the informal justice system was much more profound, much more prevalent. So I tried to develop a model. I call it the hybrid model of formal and informal justice system in Afghanistan. The idea is simply, just in 1 minute, that while retaining the positive aspects of the informal justice system in terms of accessibility, cost effectiveness, ownership, restorativeness, at the same time, we have to have specific oversight mechanisms in order to monitor potential abuses. I should have mentioned, the problem with the most informal justice system, including Afghanistan, is it is male-dominated. And sometimes, actually, it is, in Afghanistan, most forums are completely male-dominated, or only male institution, jirga, especially. And this results sometimes in women's rights violation. Sometimes local community leaders could influence the outcome. But also, to be fair, the local community leaders are more concerned about restoring harmony that is affected by crime or dispute. Here, individual rights are victimized. So the harmonization in my model of hybrid model, I developed links between institutional links between formal and informal in such a way that there is an oversight mechanism over the outcomes of informal justice system. But once that there are no violations of Afghan law, of human rights standards, and Islamic law, then that outcome should be legally binding, as if it was decided by the court. I think I should stop here.
Thank you. Thank you. One of the issues I've seen in my area of work around harmonization is the extent to which customary law or rules are unwritten. I mean, you often see it described that, in fact, it's maybe the distinctive feature between customary or informal law and formal laws. Informal law or customary law is not written, and formal law is. It's a generalization, not always true. So in formalizing informal law, if it is unwritten, that becomes a challenge, right? Whether it's done through a constitution, I think, as you mentioned in Bolivia, and we've seen that in other places, or through statute. So I'd like to have a second round of kind of questions. And I know, Hilary, you have some experience with your own tribe of kind of documenting some of what are this customary law. Could you explain a little bit about that?
Yes, sure. So Navajo Nation under American law, it's so interesting to hear all of your systems, because I think American legal system is quite different with tribes, where the Supreme Court has recognized that tribes are sovereign nations. So they're in and of themselves a nation within a nation. They're called domestic dependent nations under the law. And so at Navajo, we've really taken that value and that authority and implemented it in a way that blends the Anglo legal system with our Navajo traditional law. And so we have Anglo court system, we have district courts across the whole reservation, and a Navajo Supreme Court, that's the appellate court. But we have actually issued case decision rulings in writing. We have case precedent. It's written in English. And we also have statutes on the books. We have a 3-branch government, and we've enacted statutes that you can cite to, and that is our Anglo-type legal system, but within that, we apply Navajo traditional law. We have a concept called Hojo that's at the heart of all of our laws and our existence, which is harmony, building harmony within the universe that we live in. And then it's kinship and relationships. So for me, I'm Ashihin Nishle Naflana Bashishtin Hotsoi Dashiche and Naflana Dashanale. Those are my clans. So when I meet someone, I always introduce myself. Salt clan on my mother's side, we're matrilineal, so women are leaders in our tribe. And then on my father's side, I'm Taos Pueblo. By just saying those words, you are establishing relationships and certain laws within our community. So it is written down, and we've blended the two in a way that I think preserves our traditions, but recognizes that we have been imposed by others, have imposed on us their legal system, but we've adapted to that. The big issue now, I would say, in American law is that the Supreme Court, the United States Supreme Court, has recognized the sovereign powers of Indian nations, but there is a struggle with pure adoption of pluralism. So when tribes start to regulate non-Indians, even on Indian land, on the reservation, there is a real reticence and kind of hand-wringing of judges in the federal courts about whether or not the traditional law, like the Navajo written precedent, could apply to non-Indians. So that's still a point of tension in our courts.
Great, thank you. And any of the three gentlemen want to talk about this issue of documentation of customary or informal law? I think Justice Jallow and then Ambassador.
If I may first get to the point made by my colleague from Afghanistan very well, I think the case for the informal systems is, of course, very strong, given the cost, the complexity, and the pace of current modern litigation. So there is clearly a case for it. The customary law is very much like the English common law. It's largely unwritten. It's supposed to be understood by the people. So the people generally, especially the elders in the community, do understand what the law is on any point, on land, etc., marriage, and so on and so forth. Together, it is not statute-based. There is no legislation of it in our country at the moment. But we have the judgments of the district tribunals. These are the customary courts. We have the judgments of the superior courts, the High Court, Court of Appeal, and the Supreme Court on appeal, deciding issues of customary law, which also helps to increase understanding and awareness of what the law is. And at the same time, the Law Reform Commission back home has been carrying out a project of what we call ascertainment of the customary law, going around interviewing experts and elders on specific issues of customary law in order to determine what the law is on any particular issue and to publish it and publicize it. So that's the kind of documentation we have that is available on customary law. The codification is always an issue of the customary law, but it has advantages and disadvantages. Once you codify it, everybody knows what the law is, but then you're freezing the law. You're freezing the law, you're depriving it of the advantage of, just like the common law, of evolving with practice, of the community evolving it. And so anytime you want to change the codified law, you've got to go to the legislature in order to change it. That's why we have not gone into codification of the customary law so far. We ascertain it, we leave it to the courts to determine it through their judgments, and when we publicize the judgments as well.
Ambassador, I think you had.
Just another anecdote that this is, I would call it presidential. The short time I was in office, I was approached by this Office of Foreign Assistance on a project that provided technical assistance for land titles, that provided some technical data. It was like GPS, very sophisticated. But their concern was that there were thousands of titles that were not delivered to the people in the countryside, and they were sort of waiting. What they were waiting for, the signature of the President of the Republic, because like in colonial times, our law decided that land titles after the agrarian reform were to be signed by the President himself and the head of the land reform office. So there were thousands of them. So it's an issue of legal culture. We sort of follow up what the Spaniards brought to us because it was the king who granted land titles. So what I did, so I went to the office and said, how come we have so many thousands of titles waiting for my signature? He said, well, because your predecessor just spent a few hours a week to sign it. There's so many. I said, okay, let's get a machine to sign them. So we got a machine and probably signed, not myself, but tens of thousands. And that was very easy to solve. But the backlash, or I mean the drawback was when we drafted the new constitution, one of the things that, I mean, it was a very basic concern was let's not keep this, power of the president to he himself to sign the titles. But the politicians didn't want to give up. So we still have the president signing or a machine signing for the president. Why? Because first, it's legal culture. Second, it's politics power. I mean, the president going to every community, giving out all the titles. So it's a complicated issue.
Thank you.
I just want to briefly say that the phrase customary law, it is really inaccurate because it is not written. These are basically law-like customs, traditions, precedents, and processes that are there to resolve disputes and restore order. So my key point is they should not be regulated. If they are regulated, then what's the difference between the formal law and the sense of justice of the community? I think it is more a sense of justice of the community, their communal memories, the way they dealt with issue in the past. And customary law, whatever you call the custom, the norms, they are not really used strictly. They are used as guide. It guides the elders, to resolve a dispute in such a way that is acceptable to the key stakeholders, the victim, offender, and the community. But the sense of the justice of the community is really central to its legitimacy and to its binding nature. When I say binding, not legal, of course, it is socially and morally binding. And that bindingness, socially and morally, is more enforceable and it is stronger than just writing something on paper. So in my view, it's more important to regulate the processes, or actually even regulation is maybe a kind of framework where the processes are regulated, so that abuses are prevented or potential abuses, rather than regulating customary law, because it is not law.
Thank you. Okay, we're going to turn to you, the audience, now for questions. And I think we have a mic, and so I ask you to wait for the mic. Please, we're going to start with maybe up to 3, and direct them. You may direct them either at a particular panelist or to the panel as a whole. Please do make them questions, not statements. So, got one in the back here, one here, and one here. So those are the first 3, and we'll get to you in the second round. First one was back there.
Oh, sorry.
And please introduce yourself.
Good morning. I'm Nicola Satchel from Jamaica. And one of the criticisms that's usually heralded against customary laws is that it keeps the people from developing. And there is one set of laws that is moving with the times, as a cliche, and there is another set keeping the people from moving into that development ethos. What are your thoughts on that?
Thank you. I think one here, and then we'll let the panelists respond.
My name is Thompson Ligowe from Malawi. You spoke about retributive justice not being successful. I don't know whether you have an alternative for that. Are you proposing that we should stop it, or is there an alternative for it? Because I'm thinking that if we just think about it, if we didn't have it, what sort of world would we have been? Thanks.
I'm sorry, if we didn't have...
What we didn't have retributive justice.
Okay.
Yeah. What sort of world would we have been by today?
Okay. Thank you.
Do you hear me? Okay. My name is Lina Rodríguez. I come from Colombia, and I have two quick questions for the panelists. I am wondering how to reconcile this idea of global and traditional forms of justice in a context of large-scale violations of human rights. For example, the Gachacha courts are always put like the international example, but they were operating in a time where the International Criminal Court was not operating. So now there are legal international standards. So how to deal with this? And my second question is directed to Dr. Ali. You were proposing this idea of an oversight mechanism. But in reality, how to implement this, because the traditional leaders of these forms of justice will think that you are kind of violating the right of determination. Thank you very much.
Okay, great question. So, Hilary, you want to start?
I can tackle that one, and I'll leave the other ones.
The first one.
The first one about developing and being current with the evolving law. First of all, I think for Native Americans, we did feel and we believe we were fully developed upon European contact. I mean, we had very complex legal and political systems in place that were functioning very well. And I also believe it's important for modern Anglo government systems to fully embrace the concept of self-determination. So in America, we have statutes recognizing these values. We have presidential proclamations or executive orders that say Native American nations have the right to self-determination. And we have found that the more tribes manage issues for themselves, manage federal funding for themselves, their own economies and their own political systems, that their livelihood and quality of life increases tenfold. So I think it's really important to recognize that there's not a best system or an advanced system. One of the things I find offensive is when I meet people and they say, oh yes, Navajo, you're pretty sophisticated. And I'm like, well, why? Because we have a system that kind of looks like your system. So I think it's just important to recognize that tribal legal systems have great value. A lot of the American democratic systems based on tribal systems, which is a whole nother conversation, and to not have hierarchies of systems, because I think there's value in all of them, and collectively we have to find those sweet spots to harmonize.
Yes, well, the customary law is not supposed to be frozen. It's an evolving law, and so it can keep with the time and with the demands of the community. There are certain aspects of it back home which do pose challenges. For instance, in terms of land ownership in the Gambia, communal land ownership, plus the fact that there is no registration of individual title. Sometimes that can act as a constraint on large-scale investment in land and in the use of land in order to raise capital with banks, which require more formal documentation if you want to use the land as security for investment. But there are ways of dealing with that as well. On the penal side, of course, even though our customary courts apply a limited criminal law relating to, as I said, environment and public order offenses, the potential of the traditional system is great, even on the penal side. In the Gambia, for instance, the customary courts have really been at the forefront of pushing this idea of alternatives to imprisonment. They don't find any sense, the customary courts, in sending people to jail. And they've told us, the lawyers and the judges, many times, it doesn't make sense to send people to jail and to take care of them. Can you give us the authority to order people to clean the streets in the village in lieu of sending them to jail? Can you give us the authority to grant orders for them to be throwing the refuse or to do some other community activities? So they've been in the forefront in that kind of reform. And of course, even with dealing with mass atrocity, for instance, as in Rwanda, the traditional courts have played an important role there, not only as courts of law, but as institutions which are capable of effecting reconciliation within the community. which the conventional courts cannot do. The High Court, the judges, etc. We are not concerned with reconciliation. We are concerned about truth, guilt, or innocence. But the traditional systems are concerned about truth, about justice, and about reconciliation. So you find in Rwanda, the Gacaca system has played a very, very significant role in dealing with the vast majority and disposing of the vast majority of the cases which arose from the genocide.
I'll answer the questions that were directly addressed to me. From Malawi, yeah? I think you had a very good question, which had two dimensions. One of them was why retributive justice is a failure, even in the Western world. And the second was, so should we replace it with something else? Well, first of all, if you go back to the classical school of criminology, Bentham, Montesquieu, John Locke, one of their promises was that a retribution-based justice system will reduce crime and it will enhance human rights. But look at, Professor Margaret Levy is there. I asked this question. In the United States, look at who are in the prison. And has crime decreased? It is the lower classes, which are everywhere, probably in the Netherlands, where the prisoners are there. So this is not a success. And a huge amount of our money, taxpayer money, is very much spent on the retributive justice system. But more importantly, it has not reduced crime. But on the other hand, if you look at Japan, I teach comparative criminology with a strong restorative justice. Look, crime is the lowest there because they use very much community-based restorative justice institutions. So to me, it is not a success. The fact that we imprison thousands of people. And what should we replace? Of course not. I'm saying that the two are complementary. The two should complement one another. There is informal, restorative justice-oriented justice institution. It should complement the retributive. Of course, we need retribution. There are certain kind of crimes we can't, reconcile with the victim and offender. So the question is complementarity, not replacement. From Colombia, very good question. This was the key question of my research for the United Nations Development Program. I developed a hybrid model. I'll send you the articles, and it's also on the internet. The key issue is you're absolutely right. Elders will resist. First of all, it's against our tradition, and in a way, it is imposed by the Americans or the Europeans. So there are two mechanisms. One is internal oversight mechanism. One is external. Internal is training the elders and tell them, look. For example, if I have 1 or 2 minutes, we have a tradition of called BAD, B-A-A-D, in the traditional justice system. We had it, still it is there. When someone kills another, one option was that because the state justice could not deal with it effectively, it results in blood feuds in generations, so people kill each other. Then traditional elders, they bring the two sides together, but they say the offender's close female relative should get married to the victim's close male relative, so that the feud, the blood animosity is replaced by marriage, by relationships. But the question is, what about the fault of the poor woman? She's forced to get married. Mm-hmm. So I started campaigning against this. But I didn't say that, look, this is against human rights standards. Of course it is against human rights standards. I said, it is against Islam. And I told the elders, look, how could you do this? It is against Afghan law. So creating legal awareness and training. But it's also external mechanism. It's not against the law, only against the law. But the outcome would not be recognized. And there is a motivation for all sides that the outcome is not only accepted informally, but also legally binding. So the internal and external oversight mechanisms, it has reduced the cases of crime from 14% in 2007 when I did the research. That was 2007. In 2014, I did research in 5 central sessions. It was quite rare. It doesn't exist. The practice but still exists, but it has decreased significantly. So it is possible.
Okay, shall we move to a second round of questions? So I've got one here, there, and we'll go 4 this time. 2 in the back. So first here.
Thank you, Hans Corell, former legal counsel of the United Nations. I have 2 questions. And first, I was very interested to hear what you said about real estate. When I started my legal career in the courts in 1962, I became judge registrar of titles to land. And 10 years later, I was charged in the Ministry of Justice with drafting the law that transferred the whole Swedish land registry from big paper foliants in the courtrooms around the world, around the country, into computers. And that taught me a lesson. Unless you have a proper land registry, you simply cannot build an economy in the country, because you can't use land for example, mortgaging to build houses and to build factories and so on. So this is the first element. The second element I learned when I negotiated the agreement between the UN and Sierra Leone on this special court, and I met with the traditional chiefs. And I realized that behind every chief here in the room is also, in a sense, a judge, somebody who decides about people's disputes and so forth. And here I see a dilemma, because I realize that we can't come charging in and saying, well, you should do this and that, because this is how we do it at home. How do you balance this, in particular when you come to land, when we know that unless you have a proper land registry, you simply cannot build an economy? And in particular, Hassan, Jallow, how do you deal with the other elements of the law? How much can we say to assist and without causing problems for the traditional system, because that may have to eke out until it can be transformed into something more modern. So these are the 2 elements of my questions. Thank you.
Thank you. So next here, and then 2 in the back. Yeah.
Hi there. I guess I'll stand up. My name is Karen Whitus, and in one of my prior lives, I worked for the International Development Law Organization. And in fact, I met Dr. Wardak in Afghanistan, and we had quite an interesting talk about this model. And at that period, IDLO did quite a lot of work on one of the problems that you've noted, which is people like to go to traditional, or what we call informal justice systems, because they're quick, because they're accessible. The formal justice system may not be in their language, it may be very far away, and yet there's problems often with failure to adhere to international human rights standards and uneven outcomes of different jurisdictions when you're going to different fora. And so we did quite a lot of this work in several countries, and then we found that in some countries, the local justice organs and governments thought that it in fact conflicted with their aims for state building. And they said, look, no, we don't want you to come here and strengthen and help to improve the informal traditional sector, because then everyone will go there and they won't choose the formal sector. And we're trying to build our state, and we want people to go there. We want to strengthen the formal sector, which I don't want to really comment on whether that's a good or a bad thing, but the effect was that all of these people that had been using the traditional or informal sector were now stuck with the same problem inherent in the formal sector and still couldn't access the formal sector. So I just want maybe to get your opinion about the legitimacy, illegitimacy, desirability, undesirability of carrying on those 2 different systems, particularly in the area when you have developing countries who are interested in building the state.
Yeah, Shyama Kupaswamy. I work in the UK and in India. So my question is regarding opening up the space to discuss customary law issues. So, as you're aware, in the UK as well as in India, there's quite a bit of harmonization between the formal, informal, and the customary systems. But in the region where I'm currently working on, in the area of customary rights and land and the environment, particularly in relation to forests, the question is about whether custom from 300 years is relevant or 2,000 years before is relevant. So I'm trying to open up the question of the 2,000 year all relevance, because in terms of why is that important? Women, certain vulnerable groups, and the environment are being affected by the 300-year-old customary system. And it could be helped if we can open the debate on the 2,000-year-old customary system. So if you can give me some advice on how I can open up that space. Thanks.
Great, thank you. And then one more here. Okay, it's been reflected in other questions. So, 3 questions. Anyone ready to tackle? Ali?
Yeah, I'm happy to the question about the resistance of state justice system to embracing informal justice system. Absolutely. When I launched the report in Afghanistan, first it was in New York, and the chief administrator of UNDP actually inaugurated it. Then when I went to Afghanistan, to Kabul, when I launched it there, I was summoned by the Supreme Court and asked me that this is wrong, this is not acceptable. Anyway, I don't want to go into details. They prepared the paper to prosecute me because they saw it as a treason, because that reduced people's trust in the formal justice system. One of my key findings was that the formal justice system was corrupt. He said, how could you say this? I said, I didn't say this. It is what the people say. I said, he said, how many people have you interviewed? I said, 8,000. The Chief Justice was telling me that I wouldn't accept this kind of report unless it was based on interviewing all the 20 million Afghans. So can you see that's kind of reasoning? Luckily, I was not prosecuted. So they resist why? First of all, the vested interest. It stopped or reduced the source of bribes, because informal justice, I'm not saying it's completely transparent. There is some corruption, but much less corruption. And secondly, they're worried that it's actually take authority from them. It doesn't take authority. In the model I've developed, the final authority approval is still in the hands of the formal justice system. So in this way, it strengthens the rule of law, but it makes it more accessible with the approval of the formal justice system. I mean, just one, the option is, there is no option to eliminate it. It has to be there. And we can't leave it as it is because it violates sometimes women's rights. The only way is harmonization.
Ambassador.
Just add a couple of ideas on this idea on how the establishment reacts towards technical assistance. I would add simply that it depends on what kind of technical assistance and where it comes from. When I was at the court, we had a very vigorous, politically geared technical assistance from some countries, like the US was at that time very interested in changing the criminal system so that drug dealing business would have a tougher legislation. So it was a terrible piece of legislation that was kind of against a number of issues that were being dealt in the country, like coca growers, or how jails were filled up mostly 80–60% of people, inmates with drug-related business. So we had a clash with that kind of technical assistance, or a more sophisticated reaction towards the Spanish assistance that wanted to bring about the idea of a judiciary council or a constitutional court in the way of German, Italian, and Spanish models. So that's up to what kind of assistance you get. Or we do have some NGOs that bring about more keen to, let's say, traditional basic justice, micro-justice. There's some people here who help people towards asserting their basic rights. No problem with them. So it's, I would say, a very political issue as well.
Justice?
Yes, I think Mr. Correll is absolutely right. I mean, with the customary law land tenure system, where you don't have land title registration, that can become a constraint to large-scale investment in land, and that's why in the Gambia it's been recommended we move towards land title registration so that you can actually now use it in the economy. I think going back to the question raised by somebody else on the floor, it's not all aspects of the customary law or all aspects of the Sharia which are actually applicable in my country and in most African countries. The criminal law on the customary law and on the Sharia doesn't apply at all. It's only the civil part of it which is applicable. That's one check that exists in the law. The customary courts do apply the English criminal law in a limited way relating to those areas I mentioned, environmental law, sanitation, public order, etc. So that's one check. The other is that there is also, even for the law that applies, the customary law and the Sharia that applies, there are certain tests for their application provided by the legislation enacted by Parliament itself, in the sense that, for instance, customary law rules are apply insofar as they say they are not repugnant. The law says, insofar as they are not repugnant to natural justice, to equity, to good conscience, etc. So it leaves it open then to the superior courts, the high courts, the Supreme Court, etc., to evaluate on an appeal every issue of customary law which applies and to decide, does this infringe fundamental human rights? Is it in line with the Constitution? Is it in consonance with notions of justice? And actually to strike down that rule of customary law, if they are to think otherwise. So there's that sort of judicial oversight of the customary law and of the Sharia law application by higher courts, using, as I said, the repugnancy test, using also the Constitution, which guarantees certain fundamental rights, in order to make sure that they do not conflict.
If I could quickly add to that point, for Indian nations in America, it's important I note that the Supreme Court has said there is no criminal jurisdiction, tribal jurisdiction over non-Indians. So there are these carving out of pieces. On the 2,000-year question, looking back at rules from 2,000 years ago, just quickly, it's a complicated question, but I think one, you have to have the legislative political will to enact laws that reflect a different approach to these questions of, say, environmental protection. And that's a heavy lift. In the United States, we do have environmental review protection laws, and they're grappling in the courts right now about, does that look at climate change from a federal authorization of oil and gas leasing? How do you assess climate change when there's a lot of other sources of climate, carbon emissions? How can you trace it to this particular source? So I think modern law can evolve and adapt to new issues in the environmental stage, but it's a tricky challenge. And lastly, I'll say for my tribe, we are applying our traditional laws to environmental issues on the reservation. We just had an issue where we're planning for potential closure of a coal power plant on our reservation. And we're being very careful about environmental protection for that closure of that plant, and then looking at alternative energy in the future, always speaking to that issue of Hozhou and being in harmony. So there are opportunities to apply traditional law on tribal lands.
Great, thank you. If I could get just some clarification from the organizers of how much, when do we need to wrap up?
No.
It was scheduled to end at 12:30, but we started late, so lunch will begin right now, but take
Okay.
the time you need.
Well, I don't want to be the person standing between this group and their lunch. I can tell you that. So one more question there, just very briefly on to answer the question about land registries. I think it's a fair observation to say that we don't have examples, at least, of modern in the sense of high income economies that have developed without some way of dealing with the documentation, registration of land rights that allows some amount of transferability. That's a fair statement. But one has to be very careful because I think I see in land law if you look at colonialization, European colonialization, whether it's Americas or Asia or Africa, it typically took their system of land tenure, which was based on a certain paradigm. Often that paradigm was completely different in the countries where they went, and yet they tried to essentially export their system, which worked very well in Belgium or France or England, onto a different system. So, and often the paradigms in the places didn't even have the concept of really owning land or selling it. And all of a sudden, so that's a brand new concept. So one must be very careful about that. Creating a system of titling has in many places become itself a land grab and marginalizes or it becomes an elite power grab of what are often marginalized people. And so, yeah, it probably has to be done over time, but it has to be done very, very carefully and in understanding what the customary law is. So I'm going to allow one more question, and then we're going to wrap up and let you all go to lunch.
My name is Johnny Debe from Liberia. I've been working the last 10 years with customary chiefs and across Liberia. I'll have two specific concerns. The first is to Justice Jallow from Gambia. Could you a little bit elaborate on how customary law and tenure is carried out in Gambia? How do they administer or give rights to women and disadvantage in terms of land? And the second one is for the general, the panel. What is the benefit of harmonizing the two justice systems? What do we tend to benefit, and what do we see as the loser? What do we lose out of the process? Thank you.
So, Justice Jallow, you want to answer the first question?
All right. On how land is administered under customary tenure in the Gambia, is basically ownership is in the community, especially for the unoccupied lands. The occupied lands, residential lands, of course, there is individual ownership, but the rest of the land is based on community ownership. It is administered by the village head, or what we call the alcalo, for each village, in consultation with the elders, and it's normally given out on the basis of use. You use the land, you continue to retain possession of it. You continue to retain possession. I wouldn't say title. You continue to retain possession of it so long as you are using what is not a residential area. With regard to women, of course, they have a right to the land like other members of the community. And I think the fact that recently communities have actually chosen women as village heads and as traditional rulers, chiefs that is, has given them a stronger say in deciding on issues of land administration. It's been a very pleasant development back home when we see women actually being elected as village heads now and as chiefs. And so really being responsible for administration of land, for management of towns and villages, etc. In a brief, that's what I would say in answer to your question.
And I think what I'll do to close things up is take advantage of the second question and maybe reframe it a little bit and give you each 60 seconds to answer the question, what is gained and what is lost by replacing informal or customary, or by formalizing customary systems?
Shall I?
Sure.
Yeah. Well, it depends how it is done. If it is done properly, we don't lose anything. You basically provide more accessible, more cost-effective, and more humane justice system, which result in strengthening the formal justice system. But if it is over-regulated, like it's done in Bangladesh village courts, you lose really the social assets that you have. And if it is too loosely coordinated, then it may weaken the state.
Ambassador?
I would just say that I'm a fan of legal pluralism, since democracy has brought new times for Bolivians. I mean, we are recovering the virtues of other peoples that we didn't know about. So I would say the legal pluralism, well managed, as you just mentioned, might bring a better future for us.
I think the We need to integrate the traditional systems into the national legal system as such, but do it in a way which ensures that we preserve the advantages of the traditional systems: speed, simplicity, acceptability, accessibility, etc. I think that's important. What we gain, on the other hand, is also oversight of those systems by the professional judges and the professional lawyers. That's also very important.
I would say that what is key to all of this is to have the acceptance and original implementation by indigenous peoples themselves. And that is the key to all of this, because without that acceptance, any outside external oversight or formalization, in my experience, is set up for failure. So, and there are important values and traditions that traditional indigenous communities have that more mainstream Anglo, however you want to describe it, systems can benefit from. And I think that there can be great advantages to that. I will also close with a closing slide for all of us. So here's something to watch in the news. In Utah, this is called Bears Ears National Monument. Obama designated this monument in his last year. Under American law, the president has power to protect areas of historic and scientific interest. And this is managed by the Department of the Interior. You'll see why it's called Bears Ears, because of the geologic structure there. This is a very sacred place to a number of Native American tribes, including my own. And currently, I've got the privilege at my firm, Hogan Lovells, to be representing some conservation groups and outdoor industry in seeking protection of this place, continued protection. President Trump has opened up a review of this monument and a number of other monuments in America. And his Secretary of Interior has just announced that he's recommending consideration of reducing and changing the scope of this monument to allow for consideration of other uses beyond conservation and preservation. So I think this is, in our current events, this is an example of a former president protecting a sacred area for Native nations at the request of those formal tribal nations. And we'll see where it's headed. Very interesting legal question of whether a subsequent president can rescind or revoke a prior president's monument designation. And the statute at issue is silent on that question. So stay tuned. These issues are very alive and current around the world.
Well, I want to thank the panelists. And also, I'll just say one last thing. And this is a bit of a critique, a self-critique of the legal profession, if I will. In my experience, the one major problem that I see about trying to harmonize formal and customary systems or formalizing informal systems is often when it's left to just lawyers, they do it with very little understanding of the customary system. It requires kind of expert social scientists, I think, in my experience, to really understand what is in that customary system. And this goes along with the theme of the World Justice Project and World Justice Forum of a multidisciplinary approach to law. So with that, please join me in thanking the panelists. And I hope that over lunch, some or all of them might be available for follow-up questions. Thank you.